I'd like to call the House Health Full Committee to order. Would the clerk please take the roll? All right. Ready? All right.
Mr. Chairman, there's 20 members present. You have a quorum.
All right. Thank you. All right. Do any of the members have any personal orders? All right. Seeing none. All right. We have a busy calendar today. Item number 13, House Bill 1205 has been rolled 1 week. All right. That will bring us to item number 1, House Bill 533. Chair Lady Rudder, you have a motion and a second. I believe there's an amendment that came up from subcommittee, amendment number 3691. Is that correct? Yes. Okay, I need a motion. Okay, you have a motion, a second. Okay, if there's no objection, let's go ahead and put that on the bill. All those in favor say aye. Opposed? Ayes have it. Okay, we have an additional amendment that has been filed, but you are recognized.
That is an unfriendly amendment.
Okay. But you're recognized to tell us about your bill, and then we'll get to the
Thank
other
you.
amendment.
Okay. This bill enacts the Fertility Treatment and Contraceptive Protection Act, which provides that an individual has a right to engage in activities associated with fertility treatments and contraception. That the laws of this state do not prohibit an activity associated with fertility treatment or contraception, and that laws of this state clearly acknowledge the right of an individual to perform and the right of an individual to receive use, fertility treatments, and contraceptives in the state of Tennessee. I stand ready for questions.
All right, thank you. And we do have a second amendment that has been filed, amendment number 5589. Chairman Hill? No. Second. Okay, you have a motion and a second. You are recognized.
Thank you, Mr. Chairman. And while I don't necessarily consider the protection of life an unfriendly amendment, this amendment is intended, as we take up this legislation, it is intended to take a step back and say that if we're going to be defining terms in the code, then we need to protect life at the same time. And it was my understanding with the sponsor, whom I greatly admire and appreciate her work on this legislation, that we'd have a chance to talk about it. So I'm grateful for that. But I also feel like this amendment may or may not have the support of the committee in this moment. And I'm looking forward to working with the sponsor as we move forward, because this is an important issue. And while we're doing one thing in the code, this amendment takes it into another area of regulation. And so I'm grateful that she's bringing what she's bringing, and looking forward to working on this issue with her moving forward. And that being said, Mr. Chairman, I move to withdraw the amendment.
All right. Thank you. Without objection, amendment 5589 has been withdrawn. All right. Thank you. That brings us back on to the bill. Julie Rudder, you're recognized.
I appreciate that the amendment was withdrawn. I do believe in the sanctity of life, of course. In my opinion, that amendment was a regulation about a regulation.
Let's stay on the bill, please.
I'm trying to do that. This bill is simply about access. So with that, I ask for your support.
All right. Do we have any further questions for the sponsor of the bill? All right. Seeing none, clerk, will you please open the vote? All those in favor of House Bill 533 as amended, going on to calendar and rules, vote aye. All those opposed, vote no. Has every member voted? Does any member wish to change their vote? Clerk, will you please take the vote?
Mr. Chairman, 22 ayes, 0 nays.
All right. House Bill 533 moves on to calendar and rules. All right. That's going to bring us to item number 2. House Bill 1310. Chairlady Hilton Haynes, you are recognized. I need a motion.
Thank you, Mr. Chairman.
You have a motion and a second. And
I do have an amendment,
we have an amendment here.
4798.
Amendment 4798. Can I get a motion? You have a motion and a second. Okay, if there's no, does the amendment rewrite the bill?
No, it just adds a subsection.
Can you briefly tell us about the
I
amendment?
can. It limits fee increases in proposed rules to no more than 3% per year and no more than 5% over a 5-year period. This was an amendment that was worked on in collaboration with the food service industry.
All right, thank you. If there's no objection, let's go ahead and vote on the amendment. All those in favor of amendment 4798, say aye.
Aye.
Opposed? Ayes have it. We're on the bill as amended. You are recognized.
Thank you, Mr. Chairman. This legislation is a modernization and cleanup of the environmental health statutes. This legislation does 6 things to add in deregulation. First, the legislation will allow for the Food and Safety Code to be modified by rule rather than through statute. This is a significant change because it will give the department more flexibility to work with industry partners to update and modify food code as necessary. Secondly, this legislation deletes duplicate statutes regarding the rented premises unfit for habitation laws. Removing this citation will result in a cleaner, easier to read code. Third, this legislation updates the definition of a campground to exclude RV parks with no group amenities and year-round tenants. Fourth, the legislation will allow for pool inspections to occur once every 3 months instead of the current once per month. There has been an additional safeguard put in place that would allow for the commissioner to deem more inspections if necessary. Fifth, this legislation decreased the number of inspections required for bed and breakfasts that are currently registered in the state. These bed and breakfasts would be inspected yearly, making it more aligned with the other rental properties in the state. And number 6 was the amendment which limits the fee increases. And this was worked with stakeholders, hospitality, grocery stores, convenience stores, and the Department of Health. With that, Mr. Chairman, I stand for questions.
All right, thank you. Do we have any questions for the sponsor of the bill? All right, seeing none, we are ready to vote. Clerk, please open the vote. All those in favor of House Bill 1310, moving on to government operations as amended, vote aye. All those opposed, vote no. All right, clerk, please take the vote.
Mr. Chairman, 24 ayes, 0 nays.
All right, House Bill 1310 passes and moves on to government operations as amended.
Thank you, Mr. Chairman and committee.
That brings us to item number 3, House Joint Resolution 149. Representative Lynn, you're recognized. You have a motion and a second. You're recognized.
Thank you, Mr. Chairman. This bill is a resolution to, I call it Make Tennessee Healthy Again. And it's basically the same, it is the same resolution that we passed last year to encourage Tennesseans about, proper nutrition and exercise and enough sleep. And it's a very encouraging resolution for Tennesseans. And honestly, since this committee passed this resolution last year, I really see a lot more in the news about unhealthy foods like seed oils and artificial ingredients. In fact, the federal government just banned red dye number 3, which was very encouraging. So I think the good work of this committee is encouraging people and raising awareness about these things and how it can lead to better health. So that's what we all want and hope we can encourage in our constituents' lives. And by us just making them aware of these things, it is very helpful. So pending any questions, Mr. Chairman, that is the bill.
All right, thank you. Do we have any questions for the sponsor of the resolution? All right, seeing none, clerk, we are ready to vote. Clerk, will you please open up the vote? We are voting on House Joint Resolution 149 to go on to calendar and rules. All those in the affirmative vote yes. All those opposed vote no. Has every member voted? Does any member wish to change their vote? All right, clerk, can you please take the vote?
Mr. Chairman, 24 ayes, 0 nays.
All right, House Joint Resolution 149 passes and moves on to calendar and rules. That brings us to item number 4. House Bill 1280. Chairman here, you are recognized.
Thank you, Mr. Chairman. House Bill 1280 creates the Medical Expense Relief Fund. This is in response to, I think, something that most members have experienced in their district and many constituents have experienced, which is a situation where following the death of a loved one, TennCare, which is required by federal law, goes after the assets of the estate to offset any medical expenses that were incurred. In talking with TennCare, that number is somewhere in the neighborhood of somewhere around $34, maybe $35 million a year is what they recover. And they're recovering it from people and families of people who didn't have that much money to begin with. And so what we're trying to do with this legislation is to find an exit ramp for TennCare to be able to satisfy the federal requirement to seek payment, but at the same time protect the families of those individuals where the home may be the greatest asset that family generationally has. And so with that, pending any questions, Mr. Chairman, I seek passage.
All right, thank you. And we do have a question for the sponsor bill. Chairman Williams, you are recognized.
Thank you. Thank you, Representative Hill. I've just noticed in the language, you mentioned earlier about what the TennCare feels like that the cost might be for this fund. And could you restate that number for me?
Sure.
Chairman Williams or Hill, you're recognized.
Thank you, Chairman. And Chairman, the fiscal note has it at a very large sum, which is much larger than about what they recoup on an average, because part of the concern is that there's a subjective amount that they're not going to go after, and then they go after what there's a lot of factors at play as to what they may pursue. And so our fiscal note is setting at $250 million, which is significant. That's much larger than the 34. Our goal is to if we're fortunate to move forward, is to work on that fiscal note and get it in line with what is actually needed.
Chairman Williams.
Thank you. I do really like your bill. I do think, of course, it's a recommendation as to the amount and not an actual amount, or would have a $250 million fiscal note. But it's my understanding that they can recoup a certain period of time preceding someone's death as far as the amount. And I think that's 3 years, is it not?
You're recognized.
Chairman, thank you. I'm not sure exactly what it is. I know that there's a time frame that they can.
Okay. The reason why I'm asking these questions is as the person who brought us the language for, I think, block grant of Medicaid and our reason for our shared savings. Did you ask TennCare in your inquiry about this if shared savings dollars could be used to fund this fund that you seek to open, I suppose?
Chairman Hill?
Thank you, Chairman. And that's a great question. I think that in asking them or talking to them, it was more information seeking than asking them for input on this part of the legislation. I think part of what I'm concerned with is that and to answer your question, the shared savings is going very, very well, even to the point where money's being returned back into the general fund, which is, from my perspective, and I know that's a little bit off topic, but there's resources that are there. There's money that's there. I would rather see it go to something like this than have TennCare money go back in the general fund.
Chairman Williams?
Thank you. I do think it's important for us to see if there's a reason why we can do this. I'm a little fearful about opening a fund that we don't fully fund like we do certain other projects, but I think there is the capacity to do this through TennCare. I'm going to be supporting your bill today. It's my hope that we have a discussion about those shared savings as it relates to how they can best be utilized. I won't go as far as to say better, but best utilized. And I think this would be a good opportunity for us to do just that, because you're able to support these families who've been through a lot, but also utilize those dollars for those same resources. So I appreciate the bill and look forward to supporting it.
Thank you, Chairman.
All right, thank you. Any further questions for the sponsor of the bill? Representative Lynn, you're recognized.
Thank you, Mr. Chairman. Representative Dew, is this done in any other states, or would Tennessee be the first state if we pass this law?
You're recognized.
Thank you, Chairman. I'm Madam Chair, I'm not sure about any of the other states. I think the focus and the reason that I brought the bill was because we've got constituents that are in great need and also in limbo. I mean, in this period of time where they have got a family member who's passed, they're not quite sure what to do with the estate. They're not quite sure what to do with houses or whatever the assets may be. But no, I'm not familiar with any of the other states, what they do.
You're recognized.
Thank you, Mr. Chairman. I completely understand why, you want to do this. I think all of us have heard from constituents who face this after a loved one dies. And, basically it's because, their loved one received paid for medical care by the taxpayers of the United States of America and by, of course, the state of Tennessee. And therefore, the government does seek reimbursement for that medical care. The thing I worry about, and like I said, I really appreciate your heart in wanting to do this, and I have the same tugs on my heart. I just worry that something like this would make Tennessee a magnet for sort of moving here for end of life, because the estate would not then be gone after to recoup the medical care expenses that the loved one received at the very end. And I've never heard of another state with this, and I am afraid it might be first of its kind. And I think that the fiscal note, as stated, would probably be very low, because it would be a great draw for people from other states if the Tennessee taxpayers basically effectively picked up this. So thank you very much for this bill. My jury is out on it in my mind, because I can see the economic effect of doing this and really causing, a lot of people to flock to Tennessee, because the estate wouldn't be asked for that recoupment. So thank you, Mr. Chairman.
Chairman Hill, any comments?
And I guess, thank you, Chairman, and thank you, Madam Chair, for that concern. I guess what I would say is that we generally don't discourage people from moving to the great state of Tennessee. And what my concern is, the folks that are living here, they're participating in TennCare. And again, this is a long-standing issue where the assets of their loved ones are taken. And again, it's a debt that is owed. There's no question about that. But I think that we have found a way that we can satisfy that debt, that can satisfy federal requirements, either using the excess that TennCare has. And really, that's what the intent is. So TennCare, in effect, will be pursuing TennCare to protect people. And only in government does that make sense. But I wouldn't consider it a negative incentive for people to move to Tennessee. In fact, we would welcome.
All right, thank you. Representative Capley, you're recognized. The question has been called. If there's no objection, clerk, we are ready to vote. Will you please open the vote? All those in favor of sending House Bill 1280 to government operations, vote yes. All those opposed, vote no. Has every member voted? Does any member wish to change their vote? Clerk, will you please take the vote?
Mr. Chairman, 21 ayes and 3 nays.
Thank you. House Bill
Thank you,
1280
Chair. Thank you,
passes and moves on to government operations. All right, at this time, I actually have some bills on the calendar, but I do see, without objection, I'm going to pull up House Bill 495. Chairman Baum has been sitting there patiently, so I don't want him to have to wait. So without objection, we're pulling up item number 9, House Bill 495. Chairman Baum, you're recognized.
Thank you, Chairman Terry. And I do believe I have an amendment.
Okay, I have 2 before me. Is the both three right there? Is it 6359?
Yes.
Okay, I need a motion. You have a motion, a second. Okay, if there's no objection, let's go ahead and attach amendment 6359. All those in favor say aye. Aye. Opposed? Ayes have it. We're back on the bills amended. You are recognized.
Okay, thank you, Chairman Terry. Years ago, we put in Tennessee code maximum amounts that patients and their representatives could be charged for their medical records from hospitals. This must have been back in a time when these medical records were paper, and so the charges were on a per page basis. Today, many of these medical records are electronic. We're not Xeroxing pages and sending these pages through the postal mail. Now we're just copying PDFs, and the PDFs are being emailed. And so what this bill attempts to do is to actually help patients and their representatives by lowering the costs for their medical records when those medical records are being provided electronically. And the way the bill does this is by stating that when the request for hospital records by a patient's representatives are made for the electronic version of the records, the total charge or the charge would be a flat fee of $90. This is an amount that was agreed to by several different groups. The Tennessee Bar Association, the Tennessee Trial Lawyers Association on one side, and the companies that are the third-party providers that provide the hospital records to the patients on the other side. In the subcommittee last week, I presented an amendment that indicated that the charge was up to $90. That's the way the amendment was written. After that committee meeting, I learned that the agreement among these parties that I just mentioned was for the charge for electronic records to be a flat fee of $90. And I did tell these parties when we began these discussions some time ago that I would honor their agreement. And so this is an amendment that clarifies the bill to correspond to their agreement. And again, I think the key detail is that the charge is a flat fee, which is $90, rather than an amount that is up to $90. And it's certainly not an amount that's on a per page basis like would be the case for a paper records request.
All right, thank you. Do we have any questions? Representative Hammer.
Thank you, Mr. Chairman. Thank you, Mr. Sponsor. Just some clarity real quick then. Is it the charges for if I'm a patient, I'm requesting my own medical records or imaging files, those charges have to be included as part of this?
You recognize?
If the patient requests the records themselves, then there are federal regulations that indicate that a reasonable amount has to be charged. What's in Tennessee code that's, I guess, being changed is really the charges that would be assessed if a patient's representative requests the hospital records on their behalf. This would occur when a patient is injured or disabled and is unable to request the records themselves.
You recognize?
Thank you. Yeah, I remember the bill last year. I know this is mostly cleanup, but I just wanted to clarify that it's a may more than a shall, because I've had instances, previously I'm a cancer survivor. I've been able to take my own images and provide it to other doctors. And I'll make sure that that portability still exists without a charge if the provider's electronic health records enables it. So, thank you.
You recognize?
And I think I should add that even though what this bill does is it adds to code this amount for as an electronic records charge, I'm sure the third-party providers would have the ability to not charge anything if they wanted to, but I think it's their business. It's going to be their business most likely to charge for these records because that's how they generate their revenue. And one other thing that I could clarify is some of this probably sounds familiar. Last year's bill dealt with these charges when you request records from doctors' offices or clinics. Last year's bill did not cover hospital records. This bill is different than last year's bill in that it covers hospital records. And so it's covering a little bit different kind of record. When I went to the parties that were negotiating these prices to discuss what really was a fair amount, they did make the point that hospital records are generally very voluminous. And so you're generally talking about hundreds or thousands of pages of records. And so when when the bill proposes a $90 flat fee, the parties believe that this is a good deal for patients and their representatives because otherwise hospital records could be, again, hundreds or thousands of pages.
Good. Okay. Any further questions for the sponsor of the bill? All right. Looks like we're ready to vote. The clerk, please open the vote. All those in favor of moving House Bill 495 onto counter and rules as amended, vote aye. All those opposed, vote no. Has every member voted? Does any member wish to change their vote? All right, clerk, will you please take the vote?
Mr. Chairman, 23 ayes, 0 nays.
All right. House Bill 495 moves on to counter rules as amended.
Thank you all.
Thank you. That brings us back to item number 5, House Bill 830, and so I will pass the gavel.
All right. Thank you, Mr. Chairman. This does bring us to item number 5, House Bill 830. And I believe you have an amendment.
I need a motion.
Need a motion, second. You have a motion and a second.
Thank you. And I do have an amendment, drafting code 3503.
That's correct. I've got a motion, a second, and a second on the amendment. Without objection, we'll go ahead and put the amendment on the bill. All those in favor, say aye.
Aye.
All those opposed, the ayes have it. So we're back on House Bill 830 as amended. And Mr. Chairman, you're recognized to give us a description of your bill.
All right. Thank you, Chairman and Committee. In 2021, the General Assembly created the Medical Cannabis Commission to develop and recommend a medical cannabis program for Tennessee. Since then, the commission has struggled to conduct business due to quorum issues, and this bill addresses that issue so the commission can work to accomplish its purpose. So the bill has 2 sections. The first section reconstitutes the governor's appointments by removing the requirement that One appointee must come from each Grand Division, and expanding the eligibility to include caregivers. This change ensures better participation as many patients with qualifying conditions face challenges in serving. And the second section, with ongoing discussions about rescheduling cannabis at the federal level. The second section of the bill clarifies that the commission can make policy recommendations which would allow Tennessee to proactively develop a program that will be ready to take effect if federal law changes.
Okay, are there any questions of the sponsor? Seeing none, without objection, we'll go ahead and be voting on House Bill 830. Would the clerk please open the vote? All those in favor of House Bill 830, please vote yes. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Would the clerk please take the vote?
Mr. Chairman, 22 ayes, 0 nays, and 1 present not voting.
Okay, thank you. And with that, House Bill 830 moves on to calendar and rules. Okay, this takes us to item 6 on the calendar, House Bill 1044. Do I have got a motion and a second? Chairman Terry, you are recognized on House Bill 1044.
There is an amendment 5499 that rewrites the bill.
Okay. And that's what we've got. You've got a motion and a second. Without objection, we'll go ahead and put Amendment 5499 on the bill. All those in favor say aye.
Aye.
All those opposed, the ayes have it. So we're back on the bill as amended. And Chairman Terry, you are recognized.
Thank you, Chairman and Committee. The Medical Ethics Defense Act safeguards the rights of doctors, pharmacists, nurses, and medical students to practice medicine in alignment with their moral, ethical, and religious beliefs. It has 3 protections. Number 1, conscience protection to not participate nor pay for procedures, treatments, or service that violates the conscience of the provider. Whistleblower protection against such a conscience protection violation, and prohibits a government entity from taking action against a healthcare provider for exercising free speech. This, as amended, does not apply to procedures, treatments, or services governed by federal law, including the EMTALA, which is the Emergency Medical Treatment and Active Labor Act. It does not apply to healthcare professional or a healthcare institution when performing healthcare procedures, treatments, or services for an individual who is in imminent danger of harming themselves or others, and establishes that a healthcare payer may not decline payment for healthcare procedure, treatment, or service it is contractually obligated to pay for under the terms of a contract with an insured party. This bill has nothing to do with objecting to care based on anybody's race, color, sex, religion, nation, or nation of origin. This involves procedures or treatments that may be against your moral, ethical, or religious beliefs, including for patient safety with the Hippocratic Oath to do no harm. This type of law has been passed in several other states, and it's been in place in blue state Illinois and red state Mississippi for decades without issues. The cornerstone of healthcare should be the patient-provider relationship, and patients and providers have rights. Providers should not give up their rights to best serve their patients. Patients need to know that our doctors are advocating for them with a clear conscience. And I ask for your support. There are some people, I believe, signed up to testify. I think 1 opposed and several in support that can answer questions.
Okay, thank you for that description. And we do have some people that want to testify. So without objection, we'll go out of session to hear testimony and understand there's a Dr. Amy Gordon Bono here to testify. If you would step up and pick your chair. And you will have 2 minutes once you begin.
I was informed 3.
That's fine.
Perfect.
Thank you. Thank you. I appreciate that. I'm Dr. Amy Gordon Bono. I'm a primary care physician, board certified in internal medicine, and I've been practicing in Middle Tennessee for 14 years. I want to thank our General Assembly for turning attention to moral injury in healthcare, and I ask that you redirect your efforts in a more meaningful way. The bill before you today seeks to codify medical ethics in a manner that is excessively broad, and as a result will have unintended consequences. This is a bill that allows freedom from providing medical care. This bill does not put the patient first. When the legislation is not patient-centered, it's morally compromised to begin with. I worry this bill will lead to more patients not trusting their medical caregivers to provide the care they need. Laws are already in place in Tennessee such that a provider can decline to comply with the patient's instruction on healthcare that requires medically inappropriate healthcare or healthcare contrary to generally accepted healthcare standards. Existing parts of Tennessee Code provide protection such that no person shall be required to participate in the performance of an abortion. In fact, existing statute allows healthcare providers to decline to comply with an instruction on a patient's healthcare decision based on conscience. I have heard presentations in support of this bill that state this bill will remedy healthcare workers' labor shortages. Respectfully, it will not. In fact, actions taken by this legislative body have caused medical professionals to leave the state or leave medicine altogether. For me and for most healthcare workers, medicine is a calling. We enter the medical field with an overwhelming desire to help people. I have heard in prior committee hearings that a goal for this bill is to address moral injury, and I'd like to explore that concept with you further. Failing to consistently meet patients' needs has a profound impact on physician well-being. The moral injury of healthcare is being unable to provide high-quality care and healing in the context of healthcare. I see nothing in this bill that alleviates the regular burdens upon a healthcare worker's conscience. When patients are given treatment options that force them into medical bankruptcy, that is morally injurious. When an insurance company's opinion on prior authorization processes matter more to patient care than my educated medical professional opinion, that is failure of a system that could be changed with the right amount of political will. But time and time again, I see this legislative body choose to politicize talking points rather than prioritize real solutions to the issues at hand. This bill will not heal moral injury present in our healthcare system. The vagueness of some terms in this legislation is concerning, and overall politicians need to stop dictating medical care, and this bill allows politicians to take their intrusive efforts even further to dictate medical conscience. I urge members of this committee to please put patients first. Honor the role of our Tennessee professional medical ethics boards. Put the patient-physician relationship before the out-of-state special interest groups, and vote no on this bill. Thank you, Chairman.
Thank you. Do we have any questions while we're still out of session? I have one question, Chairman Clements.
Yeah, thank you, Mr. Chairman. I appreciate it. I appreciate you testifying here today. It's interesting anytime we try to define the word conscience, especially as it relates to medical care. You know, for generations, philosophers had tried to define what conscience is, from the Greeks to Aquinas to Freud to Nietzsche. There's been a constant debate as to what constitutes conscience. Can you outline for us what inherent problems arise from trying to overlay one's conscience with the provision of medical care consistent with your oath as a medical care provider?
My allegiance is to patients. And we have to start with the patient. And our code says that at present. If you look at how our code is defined in, TCA 6811-1808, it talks about how we start with a patient's directive on healthcare. That matter of language in our code honors the patient's wishes from the onset. So in my opinion, and the way I like to try to practice medicine, is to honor the patient first. That's where my conscience lies.
Thank you, Mr. Chairman.
You're welcome. Representative Hemmer, you're recognized.
Thank you, Mr. Chair, and thank you, Dr. Bono. The Hippocratic Oath was mentioned here, and I was just curious your thoughts on how this bill would contradict your oath that you took to do no harm.
I worry that laws like this will lead to patients not trusting physicians. I worry that laws like this will lead to physicians or patients being assumed that they are one thing versus the other, and that it will create a greater divide within the patient-physician relationship. Again, the moral injury of healthcare that has been discussed in prior committee hearings, in my opinion, lies with being unable to provide healthcare to patients appropriately.
Any other questions? Okay, seeing, oh.
Thank you.
Dr. Kumar, you're recognized.
Thank you, Mr. Chairman. Thank you, Dr. Bono. I'm struggling with the fact that the bill addresses very well that a patient demands a procedure which is against my good conscience, and I should have the right not to provide that. You mentioned Hippocratic Oath. The original Hippocratic Oath from 500 BC prohibits certain procedures, including what he called giving a pessary to a patient, which was the form of type procedure of abortion at that time. So it is prohibited in the original Hippocratic Oath, but then, of course, modern times go on to revise it, and the last revision, one I'm familiar with, is 1964. And that takes that out and adds certain things. But still, which Hippocratic Oath do you follow? And I understand your admonition that we must honor the patient, but yet we do have a conscience.
So different medical schools have you take different medical oaths. And I'd honestly have to get out the one that my medical school asked me to take. I think that, am I answering your question, sir?
Well, thank you.
Okay, I appreciate your question.
Thank you. Thank you, Mr. Chairman.
You are welcome. Representative Lynn, you're recognized.
Thank you, Mr. Chairman. Language can be very vague, and so I'm trying to get to what you're saying. And as Dr. Kumar stated, if someone asked him to do something that was against his conscience, he wants to be able to say no. So we can take something extremely extreme, and let's say for a minute that someone came to you, a physician, and said, I want you to change my gender by removing my private parts because I feel like I am the other gender. Do you feel that you would be able to exercise your conscience and say, let's say you were opposed to that. Let's say you said, well, they might change their mind. They might, they might feel better down the road, and I don't want to do anything permanent. So I'm not going to do this. Do you feel that a physician should have the right to say just that? I am not going to do this, find someone else, but I am opposed to doing this. Do you feel a physician should have the right to do that?
With the language that I'm familiar with, if that is a concern that this legislative body has, the language can be tailored to a more narrow fashion to direct to those concerns. The language here expands who can object to a type of care. The language here expands on different types of care. So there's not well-defined terms here. This bill will have unintended consequences. And if that is a true concern that you have, I recommend narrowing the bill and tailoring it to that language, not this expansive broadening.
Thank you. Representative Mitchell, you're recognized.
Yeah, thank you, Mr. Chairman. Doctor, my fear that this legislation is the first step down the path of, right now it's the procedure that affects the conscience of that physician that they're worried about. Next, it's going to be whether you agree or disagree with that person's beliefs or something other than that, goes beyond their beliefs. It may go to where they're from or something else. I just have I think there's certain professions in our country, whether it be law enforcement, whether it be, giving someone a fair trial, giving someone adequate medical attention, that you've signed up, you've taken your Hippocratic oath in the medical profession. You know what you were taught in medical school. You know the procedures that you were taught in medical school and what you may be asked to perform as a physician. And then to get to the point of picking and choosing, are we going to get to the point of we pick and choose? Well, I know your political views, so I choose not to treat you. I think this is the first step going down that path, and I think this is a very dangerous path we're heading down.
Thank you. And thank you for your testimony. And we have others to come up and testify now. Thank you. Greg Chaufin,
Dr. Mike Chubb,
Dr. Mike Chubb,
and Dr. Jonathan Shaw.
and Dr. Jonathan Shaw, if y'all would come up.
Good afternoon. Good afternoon. Honorable Chairman, Dr. Brian Terry.
Before
and-
we start, if y'all could introduce yourselves, say who you are,
Yeah.
and you'll have 3 minutes each. We'll let you each testify, and then we'll open it up for questions.
Thank you. Honorable Chairman, Dr. Brian Terry, and esteemed members of this Tennessee House Health Committee. I'm Dr. Michael Chupp. I am the CEO of the Christian Medical Association with over 13,000 members in the United States, of whom 538 of our members reside in the great state of Tennessee. I spent 20 very busy years in clinical practice as a board-certified U.S. general surgeon in the state of Michigan and as a missionary doctor in East Africa for 15 years. For the last 9 years, I've lived in Bristol, Tennessee, and have been licensed by the Medical Board of Tennessee. I'm grateful for this opportunity to talk about an issue of greatest importance to our CMA members. The Christian Medical Association strongly supports HB 1044, the Medical Ethics Defense Act, sponsored by Chair Brian Terry. In 2019, we joined the Catholic Medical Association, and we conducted a national survey of over 1,700 faith-based healthcare professionals. That survey showed that 75% of religious healthcare professionals have seen increasing discrimination and pressure to compromise their moral, ethical, or religious beliefs in their practices. 97% of these healthcare professionals reported that they will care for all patients, regardless of their agreement or disagreement with patient choices. 1 in 3 had felt pressured, forced, or punished to participate in training or perform a procedure or write a prescription to which they had moral, ethical, or religious objections. The most striking finding of this national survey among faith-based healthcare professionals was that 91% indicated they'd rather stop practicing medicine altogether than be forced to violate their conscience. Our CMA members in Tennessee are guided. I've been hearing you talk about the Hippocratic Oath, the oath to do no harm. Who of us would ever want a doctor without a vibrant and informed conscience, one that is constantly reevaluating what harm actually means, or patient care that does not actually result in human flourishing? Healthcare professionals with a healthy conscience will sometimes disagree with patients, colleagues, or institutions over the ethical legitimacy of controversial medical practices. Such disagreement, it may not make them popular among colleagues, professional societies, or hospital administrators. The Medical Ethics Defense Act, once passed, will send to those considering practicing here that this legislature recognizes their need to contend for the practice of conscientious and ethical medicine, committing to care for anyone, anywhere, anytime, but we cannot guarantee anything. Thank you.
You're recognized.
Thank you, Mr. Chairman. My name is Dr. Jonathan Shaw, and thank you also to the distinguished members of the committee. It's a privilege to speak to you today in support of the Medical Defense Act. I'm an OBGYN physician by initial training who moved to Tennessee in part for their perception that freedom of conscience is more likely to be protected here compared to where I was practicing in the Northeast. I spent 8 years in New England, subspecializing in and then practicing reconstructive female pelvic surgery. In 2018, I remember thinking that transgender surgery was an esoteric field that would be unlikely to impact my work. However, I was soon encouraged to go and learn the techniques. I did not do that, and my colleagues ended up doing those procedures. I noticed that the transgender service line and the clinic in my department growing busier and busier over the next 5 years. And then came an expectation to announce our personal pronouns. I used the term conscientious objection to describe my position on the practice of being forced to announce my own pronouns, but this was seen as a barrier to patient care. The ability to do my job was called into question, and human resources were consulted. My chair told me she did not like my language of conscientious objection and reminded me that this was 2023 after all. I was then at that time informed of a job opening in another state. The implication was clear that conscience needs to be limited or consider an alternative career path. However, not only was there a lack of evidence for supporting transgender surgery, my conscience understood that we are created by God, male and female, and we should not go against that design. So while I still had good relationships with my colleagues and a busy practice, I decided to look for a job elsewhere before I was pushed out for declining to perform those procedures. Hence the draw to Tennessee. There are other healthcare workers like me who look to Tennessee and are drawn by common sense policies which preserve the freedom to be guided by conscience as a physician. I understand my obligation to care with sensitivity and respect for anyone struggling with gender identity issues and not to harm them. And physicians guided by God-given conscience are not seeking to put up barriers to care, but are rather seeking to help their patients. And I believe those are the types of healthcare professionals that will help this state to continue to flourish. Thank you, Chairman.
Thank you. You're recognized.
Thank you, Mr. Chairman. My name is Greg Chaffwin. I am an attorney and senior counsel with Alliance Defending Freedom. I'm available to answer any questions that anybody may have. I'll use my brief time just to highlight again some of the key points about this bill. This protects doctors from being forced into doing procedures that violate their conscience. It doesn't allow them to do whatever they want to do if their conscience tells them. It just stops them from being forced to do something that would violate their conscience. This also works in practice. As was mentioned, there are 8 other states that have these kinds of conscience protections. In some cases, for 20 years, in some cases 50 years. That's Illinois. It works as intended. It's not used frequently because these are the guardrails that are meant to protect conscience rights for doctors. And doctors know that if they assert them, they're still putting their livelihood on the lines. But just like good guardrails aren't hit frequently, these need to be in place to make sure that healthcare professionals can exercise their practice with their conscience intact. Now, those are sincerely held religious or ethical moral beliefs as defined in the bill. And as I said, you can look to these other states that have years and years of exercise with this bill in place that it works in practice. As was mentioned earlier, patient trust. Of course, we want doctors with ethical integrity, and we want to know that our doctors will not be forced to do something that they think is unethical. The protections in this bill for healthcare professionals means that patients can find second opinions. Without that, You can't get a second opinion because there will be a one-size-fits-all approach to medicine, and we know that that's not good for patients. This encourages diversity. It encourages opportunity and openness for people to enter the medical field. It tells young people of every sort, young men and women, that they can be doctors, nurses, pharmacists with their conscience intact. Too unfortunate if there's somebody out there that thinks there's one procedure or one thing that I have a conscientious objection to, whether it be euthanasia, a certain type of abortifacient pill, or something that would take them out of the medical field entirely. Those are people that would love to serve everybody, but there are certain procedures that they cannot in good conscience protect. So as I said, I'm available for any questions that you might have. There's plenty more that can be said about this bill, but as I said, this works in many states, and it would be great policy for this state as well.
Thank you. Thank you for your testimony. Any questions? Seeing, okay. Chairman Clemens. Representative McKenzie, you're recognized.
I defer to Senator.
What? Representative McKenzie.
Thank you, Mr. Chair. So as I listen to you all discuss the issues or the support you have for this bill, the numbers just don't number for me. And that is the first gentleman you talked about people surveyed, and you said 90% of them said that they were forced to do something, and I think we're generally talking about, transgender kind of conversations. And last I checked, a high number is 1% of the United States population. And the second gentleman talked about an increasing number, like the transgender lab was just blowing up, becoming, one of the largest departments. I'm not going to say that. You said that that the transgender center or whatever you called it was growing in significant numbers. I guess so are you saying, to the first gentleman, the 90% of the people that were complaining about being forced to do something, a procedure or a treatment, was because of transgender? And if not, could you give me 2 or 3 of the other types of things that their conscience wasn't allowing them to do if they're not, let's say, male, female, productive realm?
You're recognized.
Thank you. Representative McKenzie, thank you for a good question for clarification. I think the number was 75% of our members have said, and this dates back even before 2019. This is not just related, this is many issues, especially including abortion, end-of-life care, assisted suicide, gender issues. Those would be the 3 big things, the controversial issues that are big in our culture, in our society today. So this is not focused on gender-related care, but on it was a general question about practice and whether you've been pushed to compromise your conscience. I don't know if that answered fully. The 91% had to do, Representative McKenzie, with I would rather leave medicine than to be forced to violate my conscience.
Representative McKenzie, follow up.
Thank you, Mr. Chair. And while I definitely appreciate that answer, these bills tend to be one-sided, like your gentleman to your right. His focus was on that. And I think generally speaking, people aren't as concerned with, I don't think the genesis of I think the genesis of this bill as we read into it is more of that realm. And I'll end with, and maybe you can comment on this. I've lived in this great state my entire life, and I think it's the best state of all 50, and evidently you all do as well. My concern is you came here for a reason. You came here because of our conservatism, whether red, blue, whatever. We're generally a conservative state, believe it or not, all folks. But you guys come here wanting to change. That's my concern. You came here for a reason, not because it's 100% your way, because unlike the Northeast, it may be a preponderance of your way. But now these bills come here and try to put us all in one camp. conscious is your definition of conscious. That's my concern with this. It's like you're in a great place. You're both liking where you are doing, but you're here trying to push the needle even further, to swing the pendulum and duct tape and super glue it into your position. And that's my concern with bills like this. We are, as it relates to our physicians, we're probably the country's most restrictive as it relates to female health and abortion. But we want more, and we want to continue to push and push and push. So my answer is, to what end? Is that means you get everything your way? Is that what your conscious is, your definition, and not another physician who may think a little different, who's, speaking to us as well?
Was that question directed to me? Okay. Thank you for the question, Representative McKenzie. It's certainly not my desire to come and change. I think this is a great state, and I haven't loved it so far. So thank you for having me. Regarding wanting to change, the question was asked earlier where our conscience comes from, and I'm not going to fix thousands of years of philosophy, but if one doctor's allegiance is to the patient, I would say that my conscience allegiance is to the designer of the patient, the God who created the universe and the rules and laws that we live by. So I can have allegiance to both the patient, to do no harm, to help her, and to the God of the patient as well. And one does trump the other. I'm not trying to change anything. I'm just trying to recognize reality and the universe we live in. And I think there are good people here and good policies that recognize that too.
Thank you. Chairman Terry, you're recognized.
Thank you. I was just going to ask Ms. Schaffen about these laws being in other states and how they've worked and any challenges, or give us your feedback on that.
Yes, sir. Thank you, Mr. Chairman, Mr. Vice Chair. So yes, in 1977, Illinois passed conscience protection. In 2006, Mississippi did one. And then in the last 7 years, we've seen, so we're up to 8. So 6 more states have enacted similar legislation following the language like what Mississippi has. Of those, you have Florida, Ohio, Arkansas, South Carolina, Montana, and Idaho. And they work as intended. Very few cases. I think there are 2 cases over all those years. For example, in Illinois, there was a pediatric nurse who served kids for years. I love taking care of kids. But then when her pediatric care unit was combined with the women's health unit, she was told she would have to refer people for abortions and participate in that. And she fortunately was able to use their conscience protection law to not have to violate her conscience. But at Alliance Defending Freedom, we have served a lot of people who have been put in situations where they don't have conscience protections. And they have faced a worse outcome of having to be complicit in those procedures because hospitals did not respect their conscience rights.
Thank you. Follow up? See no follow up. Representative Travis.
Thank you, Mr. Chairman. I make a motion, we go back in session.
Second. Okay, we have a motion and a second. If there's no objection, I see 4 objections. So we will go to the board on this. Madam Clerk, if you will open up the vote, and we're going to be voting yes to go back into session, no to stay out of session. Has every member voted? Does any member wish to change their vote? Okay. Clerk, would you please?
Mr. Chairman, 14 ayes, 7 nays.
All right, thank you. So appreciate everyone's testimony there. We are back in session. Okay. Chairman Terry. Chairman Williams. Excuse me if anybody has anything to say. Representative you and you, address the chair, please. And thank you for seeking recognition, Chairman Williams, and you are recognized.
Thank you. Thank you, Chairman. Chairman Terry, Dr. Terry, if this bill were to pass, if your conscience was not, if you didn't have an objective, to something, could you perform that procedure? Yes. Okay, thank you.
Okay. Then Representative Capley, you are next on the list.
Question on the bill.
Question's been called.
Objection.
1, 2, 3 objection. He was next on the list. He truly was next on the list. Excuse me.
Point of order.
You pointed to him. I went to you first. You pointed to him. That's why I went on to him. We've allowed people to speak.
I wonder, question I hate word that you had before us.
The question's been called. We have objections.
Point of order.
I don't know that a point of
Order.
overrides.
Okay, recognize McKenzie.
Masons makes you you have to acknowledge a point of order.
I'm not sure what the point of order is.
Okay, you're recognized for point of order.
Thank you, Mr. Chair. The point of order is you did not recognize people, members, colleagues in the order which their hands went up. That is the way the process dictates. It does not allow you to skip around. That's my point of order.
I'll address that. I did take them in the order that I and staff saw the hands go up. And just frankly, as a matter of physics, how do you know if hands went up behind your back when you're looking forward anyway? But that's probably going a bit out there. And we've still got our motion. And we had objections, so we will go on the board. Previous question, we had multiple objections. So we're going on the board for the previous question. A vote of yes is for the previous question. A vote of no is opposed to the previous question. Has everyone voted? Does anyone wish to change their vote? Has everyone voted? All right. Clerk, please take the vote.
Mr. Chairman, 16 ayes, 5 nays.
Previous question has been called. We're on the bill as amended. Clerk, would you please open the vote? And all those in favor of House Bill 1044 as amended, please vote yes. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Okay. Clerk, would you please take the vote?
Mr. Chairman, 16 ayes, 5 nays, and 1 present not voting.
All right, thank you. And with that, House Bill 1044 is on to calendar and rules. This brings us to item 7, House Bill 510. Do I have a motion and a second?
Motion.
Second. I have a motion and a second. Chairman Terry, you're recognized. And I believe we have an amendment on this bill. Do it.
Yes, drafting code 5501.
That's what I've got. Without objection, we'll go ahead and put the amendment on. All those in favor of Amendment 5501 on House Bill 510, please indicate by saying aye.
Aye.
Those opposed, no. The ayes have it, so the amendment goes on the bill. First, let me go. The amendment's on the bill. All right. You're recognized,
Yeah.
Representative Mitchell.
Thank you, Mr. Chair. I don't believe we heard a motion or a second on that amendment.
We'll make sure. Motion on the amendment,
We had one.
second on the amendment.
And revote.
Yeah, I
again.
think we did, but
Revote
better
again.
safe than sorry.
Revote again.
All those in favor of the amendment?
Aye.
All those opposed? Bam. There you go. Now, on the bill as amended, Chairman Terry, you're recognized for a description.
Thank you, Chairman of the Committee. The AMA has projected that the U.S. is facing between a 37,000 and 124,000 physician shortage by 2034. The Association of American Medical Colleges has echoed those projections, estimating that we're facing around 90,000 physician shortage by roughly the same time period. What this bill aims to do is acknowledge the physician shortage problem and have the Department of Health compile information relative to the physician shortage and provide it to us to use in policy decisions such that we can better address the physician shortage of our patients.
Thank you. And with that, are there any questions of the sponsor? Chairman Clemens, you're recognized.
Appreciate it. And thank you, sponsor. I'm looking at these recitals and these whereas clauses, and I don't see anything about in here. We got a real shortage of healthcare workers, especially in rural areas. So there's nothing in here about if all these too few doctors in these rural areas start refusing medical care because of their conscience. Why is that not addressed in this resolution?
Chairman Terry.
Thank you, Representative Clemens. And in this, they will reach out to the different organizations to gather information from them. And if that's an issue in the rural areas, then that would be responsive in the survey.
Chairman Clemens, follow up.
Yeah, thank you, Mr. Chairman. And yeah, I mean, I think we got a real problem here. If you got people needing vital medical services and their doctors don't want to treat them because they think they're unethical or their conscience dictates that, that's certainly something we need to consider. And I hope that this little board that we're creating here is going to figure that out and talk about how that's impacting patients statewide. Thank you.
Chairman Terry.
Thank you.
Okay. Representative Travis. Question's been called. Without objection, we're going to be voting on House Bill 510 as amended. Would the clerk please open up the vote? All those in favor of House Bill 510 vote yes. Those opposed vote no. Has every member voted? Any member wish to change their vote? Would the clerk please take the vote?
Mr. Chairman, 22 ayes, 0 nays.
And with that, House Bill 510 moves on to calendar and rules. This takes us to item 8, House Bill 203. Got a motion and a second. And Chairman Terry, I believe there's an amendment on this one as well.
Drafting code 6356.
Motion.
6365, actually, is that what you
Excuse me,
got?
6365. Don't have my glasses.
Okay, 6365. I've got a motion and a second. Without objection, we're going to be putting the amendment on the bill. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it. The amendment goes on the bill. We are now on House Bill 203 as amended, and Chairman Terry, you are recognized.
Thank you, Chairman of the Committee. This amendment requires the Board of Nursing to develop a survey that collects certain information from nurse practitioners who have been issued a certificate of fitness by the board concerning their specialty. It requires the Board of Nursing to send a report to the General Assembly by January 15th, 2026. Currently, the Board of Nursing and the Tennessee Nurse Association is not tracking this data, so it's similar to the previous bill, but we're collecting certain data so that we are hopeful we can potentially craft future legislation that will better help the patient-provider relationship.
Okay, thank you for that description. Are there any questions of the sponsor? Representative Hemmer?
Thank you, Mr. Chairman. How are we contacting them, or how are we getting their contact info? Is it whatever's part of their licensure application?
That's my understanding.
Okay, thank you.
Follow up? Seeing none. Any other questions of the sponsor? If not, then without objection, we'll be voting on House Bill 203 as amended. Would the clerk please open up the vote? And all those in favor, please vote yes. Those opposed, vote no. Has every member voted? Any member wish to change their vote? Would the clerk please take the vote?
Mr. Chairman, 23 ayes, 0 nays.
Thank you. And with that, House Bill 203 moves on to calendar and rules. And I think that finishes the Chairman Terry calendar, and I'll move the gavel back.
All right, thank you. That brings us, we have already disposed of item number 9. That brings us to item number 10, and I have received word from the sponsor without objection. Item number 10, House Bill 387 has been rolled 1 week. That brings us to item number 11. Is that off notice?
No.
Okay. House Bill 1201, Chairman Kumar. You have a motion and a second. You're recognized.
Thank you, Mr. Chairman.
And so we have an amendment. Are we going with amendment 6109? Is that correct?
Yes.
Okay, I need a motion. We have a motion and a second on amendment 6109. All those without objection, all those in favor say aye. Opposed? Ayes have it. We're back on the bill as amended. You're recognized.
Thank you, Mr. Chairman. House Bill 1201 addresses the problem of the fact that appointment with a doctor is hard to get, and that relates to physician shortage. As your bill's already mentioned, the numbers can differ depending on which year these are extrapolated to, but there's a shortage of physicians as much as 124,000, and in Tennessee alone, shortage of physicians up to 6,000 by the year 2030. To correct that shortage and attract more physicians to our state, in 2023 and 24, the legislature passed bills to authorize the Board of Medical Examiners to issue provisional license of 2 years duration to graduates of international medical schools, including U.S. citizens. Upon completing that time, they are entitled to an unrestricted license. The qualifications include graduation from a recognized medical school, passage of 3 required exams, that is the exam for foreign medical graduates, the United States Medical Licensing Exam, Step 1, Part 1 and 2, a job offer from a medical institute, as well as a legal visa for entry to the United States. And while these laws are in place, the entry of these graduates was restricted to institutions that have a training program. And it turns out that in Tennessee, we have no more than maybe 14 to 15 training programs. So our yield was small. States, although we were the first in the country to have this program, states of Alabama and Florida have gone farther and opened the places where these graduates can train to federally qualified healthcare centers, rural clinics, community health centers, postgraduate training programs, as well as specialty clinics. This bill corrects that difference so that we are including these sites of training within reach of the graduates that we are trying to recruit. With that, Mr. Chairman, I'll be happy to answer any questions.
All right. Thank you, Chairman Kumar. With that explanation, do we have any questions for the sponsor of the bill? Chairman Clemens, you're recognized.
Thank you, Mr. Chairman. My question was to, I appreciate the spirit of the legislation, Dr. Kumar. My question is as to why we're requiring the board to issue the license rather than saying that they may issue the license. It sounds like they've got little discretion here. As long as these certain boxes are checked, then they have to give that license. But so we're taking the discretion away from the board if given any other extraneous factors. Can you speak to why it's a shall versus a may?
You're recognized.
Thank you. Well, as in most situations, there are two parties negotiating. The board would have liked it that they may issue a license. The other side wanted to say shall issue a license upon meeting qualifications. So the language that we selected is that barring any disqualifications, just give me a moment. Thank you. Yes, barring any disqualifications determined by the board shall issue. So it does entitle the graduate who has met all requirements to a license, yet the board has the discretion that if they find any disqualifying factors, they may deny this, but they will have to identify those factors.
Chairman Clemens.
Yeah, thank you, Dr. Kumar. My question is, so why shall versus they may, given the possibility for other factors?
You're recognized.
I think it's a matter of semantics. May will mean that the board may deny without explaining the reasons. Here, the board may deny, but they have to specify the reason that the license is being denied, although the candidate has met all requirements.
Thank you.
Chairman. Okay. Any further questions for the sponsor of the bill? All right. Seeing none, we are ready to vote. Will the clerk please open the vote? All those in favor of House Bill 1201 as amended, going to calendar and rules, vote aye. All those opposed, vote no. Has every member voted? Does any member wish to change their vote? The clerk, please take the vote.
Mr. Chairman, 21 ayes, 0 nays.
All right. Thank you. House Bill 1201 as amended passes and goes on to calendar and rules. All right, members of the committee, we are coming up on a hard stop. So with that, all bills remaining on the calendar will be rolled to next week's calendar. Seeing no further business before us, we are adjourned.